Everybody, if you could please have a seat, it's 9:30. We are going to open the public hearing for House Bill 1046, but before we do that, if everybody will please join us in rising for the Pledge of Allegiance. To any representative that's joining us today, thank you. Welcome. And do we have a prime sponsor for House Bill 1046? Certainly.
Good morning. For the record, I am Lauren Selig, and I represent Durham, which is Stratford County District 10. And I am simply reading 1046 FN, which is an act requiring a boat owner who is not the operator to notify law enforcement and file an accident report in certain circumstances. And that's all I can tell you about the bill.
Thank you, Representative. Sergeant Dirth?
Good morning. My name's Josh Dirth. I'm one of the... Oh. Oh, so I don't have to hold it. Okay, so this is my first time here, so I apologize. Okay, no problem. Well, good morning, Madam Chair and other members of the committee. My name is Josh Dirth. I am a sergeant with New Hampshire State Police Marine Patrol. I'm here to speak to House Bill 1046, which is basically adds teeth to an existing statute that would require the registered owner or the owner of a boat to report a reportable boating accident. I think the couple of key takeaways here to this is it could be property damage only. We had a case like that. If I was to recall your attention back to this last summer up in Winter Harbor on Lake Winnipesaukee, close call, high property damage where a boat went through a dock and through a hackercraft, antique style boat that was at the dock that had been occupied just moments before. In addition to that, though, this could simply be a bodily injury style event that could happen. And we had one of those just within the last couple of weeks over on the Winnipesaukee River. So what this does is it puts the onus on the owner of the boat if the operator fails to comply with the statute. It's not fail-proof. It does still require culpability. So that means the state would have to prove culpability that the owner did know that that boat was involved in an accident. But if we could prove that, then that would give the state some additional teeth to bring those people accountable that were involved with this boating accident. I'm happy to take any questions that people might have about the existing statute.
So we will get to questions in just one second. For our committee members, we thought that what you have in front of you are actually the Senate bills that were assigned to our committee. And Brad has been kind enough to pass down copies of the bill that were over there. So we're all going to just need 1 second because unfortunately we haven't seen this yet. My law book is in the other room, so we may need that as well. But let's start. As that's being passed around, I think I saw a ton of questions. Where are we at? Representative Selig.
Thank you very much. And thank you. I know I'm behind the speaker. It's hard to see me. So I'm curious, as someone who boats on Winnipesaukee, there are a lot of companies that rent boats. So therefore they're the owner, various marinas that rent boats. And so I'm curious just how how this would work for someone who, how are they going to know in some of these circumstances to be able to report if obviously there's paperwork that they tell people they're supposed to do these things, but since we know people sometimes forget to make good choices, I'm curious how that relates back to that.
Great questions. I'm going to try to maintain eye contact and so you can hear me as well. So I think it's specifically to address your question about rentals. Every time a rental comes back in from being used, they do an assessment on it. Typically, they'll pull that boat all the way out of the water to check the boat for any signs of damage. Some renters find hard water out there, okay? In other words, they hit a rock, they cause some type of damage to the outdrive, and then, of course, they fix that. The threshold in New Hampshire is $2,000 worth of damage, either to one boat, multiple boats, or to include property damage of something else. A dock is a good example of that. So when that happens, yes, the onus then would transfer to them as the owner to make sure they're reporting it to Marine Patrol so that we can investigate that boating accident. You're welcome.
Representative Stone?
Thank you, Madam Chair, and thank you for taking my question. Looking at this bill, it basically kind of mirrors the conduct after an accident statute in the Motor Vehicle Code. Is that your interpretation of it?
Yes, sir, it does. If we go far enough back, I'm going to say about 20 years ago, there was a fatal boating crash that took place on Lake Winnipesaukee. And none of this statute, none of this language existed then. And so really, although we knew the operator, we knew the boat, we had nothing to fall back on. And so after that, in the wake of that, this statute really developed a lot of these reporting teeth and the conduct after. This simply just adds another piece to it, if you will, to, again, hold people accountable if they know that the boat was involved in this boating accident. So, yes.
Thank you.
You're welcome.
Representative Newman?
Yes, hi, thank you. I don't have any experience with boats, but as in current, I guess in the current time that we are in, so many houses and cars have security cameras. Do you see that or are aware of that? People with docks or maybe even on their own boats that have security cameras to help with this kind of thing?
That's a great question. On boats, no. Some of your larger boats, perhaps. What we are seeing more and more of, though, are security cameras that are affixed to people's docks because so much of it can be done wireless now, and then it goes real time to their phone. The other part that we are seeing is everyone has a cell phone. So if I cause a crash or if I'm in any way involved, because it's boating related, it's somewhat sensationalized to begin with. People, I think, instinctually take out their cell phone and record it. I'll go back to the event that happened this last summer up in Winter Harbor. Some of the best evidence that we had was people's cell phone footage. So although not a security camera, I think it goes to in line with what you're asking about.
Thank you.
Welcome.
So just for committee members that have never been on a boat, I will let you know that I was actually involved in a boating accident once. And a friend of mine had a very nice boat, had a toddler in a car seat on the boat. And the boat that I was in was hit by a person operating a rental boat and put a nice giant hole in the side of the boat that I was in. And while we were about to be hit with said boat, the operator dived into the water because he panicked. Then his wife that was driving the boat pulled away, left him in the water because she was paranoid and panicked because she was in a rental boat. That person knew that they were involved in a wreck. It was very obvious, but had no intention of letting the boat company or the rental company know that they hit the boat. And I believe, if I'm not mistaken, is that what this is like addressing?
That's one of many examples where this would be applicable. So the onus, like all criminal statutes, right, is on the state to be able to prove that culpability. So knowingly does come into play. But to answer your question, yes.
Representative Muse?
I'm wondering how this proposed bill and the requirements for for owners compare to, I guess, comparable motor vehicle law? I think one of the things that I know I look for sometimes is to try to make sure that if we're changing the law for one thing, we're not necessarily doing something that would be completely out of line with how we handle it in a different area. So is there something comparable like this for motor vehicle owners?
I would make the argument, sir, that it is comparable. In other words, it parallels it. So if we had a motor vehicle that was involved in an accident, let's say it's a hit and run, and then they drive away, but someone had a cell phone and they snapped the picture, took a video, and they had the license plate, and then it comes back to somebody else. If I can attach the owner to it and the fact that they knowingly did it, in other words, the vehicle wasn't taken without their consent, then I think you have that nexus. And I think that this is what this bill does, is it cleans it up, and it again allows us to be able to go after the registered owner if that operator for some reason is not reporting. So again, this isn't an owner that is now a victim. This is an owner that knows that their boat was involved and is simply failing to report.
Thank you.
Representative Newman?
So let me just see if I can summarize what I think this bill is trying to do. The operator is supposed to make a report, and if they can't, or they won't, or they refuse, then as soon as the owner of the boat then becomes the one responsible for making a report as soon as they find out. And if they fail to do it, and the change here is if they fail to do it immediately when they find out, then they are then subject to the penalty, and the penalty is a Class A misdemeanor. And that was not changed. So it's only about the immediacy and who's responsible for making the reports.
That's correct, sir.
Thank you.
Any other questions? Am I missing anybody's hands? Oh, Representative No.
Thank you. And thank you for taking my question. So I'm just wondering, especially when it talks about, somebody getting into an accident and the owner needing to report, who wouldn't necessarily be operating the boat at that time. I think in some of the all of the examples that we've heard so far, there will be a lot of damage with that. And, I'm just thinking about other examples that may not cause immediate damage. And rather than a rental, it might be somebody who's lending their boat to somebody else or other situations like that. And so I guess what I'm wondering is about the burden of proof that that person actually knew that that boat was involved in an accident, or, you know what I mean?
That's a great point, and we can't completely mitigate that. So that threshold for us on the boating side is $2,000 worth of damage. And so if it was less than that, even if damage occurred, whether it be property or to the boat, now you're simply looking at a civil claim, best case scenario. If it's injury related, so beyond first aid, then that would automatically trigger that reporting requirement. It does not change, though, us having to be able to say, is the owner aware of the fact that this accident took place? And upon being aware of it, did they take the action to report it? So it's something, it would not be accurate if I said it would apply in all situations or if it's a fail-safe. It is not.
Okay, thank you.
You're welcome.
Anybody else? We're all set? Well, thank you very much for your testimony. We appreciate it.
Thank you.
Anybody else? That's it? Is there anybody else here that wishes to testify that has not turned in a card? All right. Well, with that being said, I will close the public hearing for House Bill 1046. And to our committee members, Representative Roy is at the Senate getting ready to testify on our bills. So we do have executive session that starts at 10 o'clock. However, I think we would all agree that me opening and recessing the 10 o'clock hearing or the 10 o'clock executive session in order for him to help get our bills through the Senate is definitely a good thing. So with that being said, I have to be here to open our executive session at 10 o'clock, but anybody that would like to go to the Senate and tell them to pass our bills, if you just let me know that you're going to do that, we have to go into recess anyway because he's not here. Representative Newman?
at 10 o'clock, we are going to be leaving and going to see the kids from Charlotte Avenue School. So we'll be over there for a while, but that's right across from the Senate.
Okay, well, so when he comes back, when he comes back from that, we'll definitely have to go into executive session. So,
No, I understand that.
Okay.
We shouldn't take long. It's just greet them and whatever.
oh, you mean the school is here visiting?
Yes,
Okay. All right. So,
that's fine. It
Okay,
shouldn't- it
so
shouldn't be
let's-
much.
yeah, that's always a good thing
Yeah.
so let's talk about this for a second. I feel like I'm in a classroom right now. I'm sorry. Does anybody who wants to stay for recess? Who is anybody that wants to go over to the Senate and say, hey, please pass our bail bills? Does anybody want to do that?
I have to chase a bill in Commerce.
Okay, you go chase the bill in Commerce, Representative Prue. Oh, what time you gonna be back, Representative Prue? This is so funny.
So when you come back and start, let me know, and I'm gonna leave them a note to have them text me when they're close to my bill.
Okay.
Haven't done it
All right. So my people will text your people. Okay.
Yeah,
Representative Wheeler, Representative Reed, you want to go over the Senate? You're staying? Okay. Read out. Wheeler. Okay. So Representative Muse and Representative Wheeler, you're choosing to go over to the Senate. Okay. Anybody else want to go over? Just so I have an idea when, where we're all at. That's all. Okay. All right. So I'm going to let Chairman Roy know. Representative Wheeler, hold on. Representative Reed, be quiet. So we are going to let you guys are going to go over to the Senate. I'm going to let Representative Roy know that I'm going to stay here to open our executive session at exactly 10 o'clock. And then when he comes back, I hope that anybody that is also there comes back so we can open up and begin our executive session. I think we're all on the same page with that. We all good? Okay. All right. Nice job working through that. I think he said that the hearing starts at 9:50, so walk quickly. Good morning, everybody. It is 10 o'clock. I am going to open the executive session for House Bill 1366. And I'm also going to immediately go into recess, which we are now in recess. Actually, I probably should have said for those watching, I apologize. We have to go into recess because our chairman is over in the Senate trying to, or actually not trying to, he's testifying on the House bills, the bills that we worked on all summer. And it is pretty important to the public that we pass those. So anybody that's watching at home, if you could just, do your best to hang tight. And as soon as our committee is back from testifying, we will reopen the executive session for House Bill 1366 and make decisions on that. Thank you very much. We are in recess.
Morning, I'm opening the executive session on House Bill 1539, and I'm going to recognize Representative Wheeler to make a motion.
Thank you, Mr. Chairman. I'd like to move ought to pass on HB 1539.
Is there a second? Second, Representative Murray. Would you like to speak to your motion?
Yes, please. Thank you, Mr. Chairman. I don't think we need to talk about this bill too much. We got 3 bills on the docket today, and I think we may have an opportunity to get out before 5 p.m., which would be nice given how much work we've done in the last couple of weeks. This bill is essentially a bill to make sure that people who have rehabilitated themselves and are out of prison and people who are trying to get a job again can have their records annulled from a charge which at this moment is be in the process of being legalized by the New Hampshire State House, and by many metrics for industry standards is no longer something that they're going after. So we're hoping to get it to the point where we're not, as I said in my testimony, in a situation where we've legalized and then people who, and the state is sanctioning smoking, selling, and the use of cannabis while people are still in jail for smoking, selling, and using cannabis. So, and having that on their records. This keeps people from being able to get loans and etc. And that's why we have an annulment statute. I think the automatic annulment statute that's put in this bill, which is really the most important piece to my mind, is well crafted and done a good job there. Only 6% of people in annulments generally, this is a national statistic, get their annulments. They don't petition the court because they either don't know or they are unaware that it's available to be annulled. So that's why it's important, I think, in this bill to have that automatic annulment statute, which would not be an onerous cost for DOS. As we talked about in the testimony, this is not something that thousands and thousands of people are going to be eligible for. Very few people have only a cannabis conviction on their record, but it's those people who are so wrapped up in the system that they can't, they made a mistake and they served their time and they'd like to get that annulled. It allows for a resentencing petition. The court's standards on that are pretty high, and I think that we can I have faith in the court system and the judiciary here to make sure that nobody who has any other, and as it states in the bill, nobody who has any other extra crime or anything on their record can get that resentencing, and that resentencing bar, even if it is just a cannabis charge, is very high as well. So this isn't going to create any crazy situation. This is just going to allow for people who want to be fully functioning members of society again to have their records cleaned from something that we've determined is decriminalized. So with that, Mr. Chairman, I will get off my soapbox and thank you for allowing me to speak, and I appreciate you for taking up this bill.
Representative Murray, would you like to speak to your second?
Thank you, Mr. Chair. I think the previous speaker covered it very adequately. I would just reiterate that we did just pass a legalization bill out of the House, and I always said I could not support legalization without annulling those who have been criminalized for something that we're now trying to allow to be sold in the state. So I do support the OTP motion on this bill.
Thank you. The concern I have with this bill is that it raises the legal limit of cannabis versus what's already legal, or I believe even contemplated. Could you address that?
I can, Mr. Chairman. So somebody would have to serve out their sentence to petition for annulment. You could petition for resentencing, but like I just said, that's a high bar. In most cases, somebody's going to have served out their sentence and have completed the sentence on what would be a marijuana charge for 2 ounces or less, and then that person can get the annulment, but that's after they have served their sentence. So I don't see it as legalizing, as you put it.
Representative Murray, you wanted to address that?
Yes, thank you, Mr. Chair. So am I correct in saying that this isn't changing the current possession limits because that's in a different part of statute, and this is only related to the possession limits that are referred to regarding annulments.
Correct. Yeah, and it's more personal use amounts for for what would be eligible for annulments.
Representative Willie, you had just said that the person has to serve out their sentence, but on line 30 of page 3, it says any person who was convicted of any cannabis-related offense who has not completed their sentence may at any time petition the court in which the person was convicted for resentencing.
Well, I don't want to say you misheard me, but you might have. No, it's not. You're able to petition for annulment if you're still convicted. But if you're still convicted, that's a much higher bar than if you're completed your sentence and that's complete there. So you're able to petition for that, but that doesn't guarantee that you're going to get it from the court. It doesn't guarantee that you're going to have your sentence resentenced. It doesn't guarantee that you're going to get an annulment. It's just allowing you to have that petition by the court. And anyone who petitions, I would imagine, thinks that they have a case for getting that annulment.
If the legalization bill that we passed doesn't pass the other body or isn't signed by the executive, does this still go through, or is there a trigger? Is it connected?
No. This is a separate bill that works in tandem with 1633. This system would ensure that people can, as I stated in my testimony, get their annulments. And the 2 ounces limit is because people aren't arrested for 3/4 of an ounce. And people, we're talking about their cannabis charges being able to sort of get, as I say, get back into jobs, get their loans. People who have rehabilitated themselves or shown a path to rehabilitation. And yeah, so that's...
No, I guess for clarification, what I'm asking is, if the legalization fails, right now it's still illegal unless you have a medical card. If the legalization fails, this bill does not go into effect, or it would, because otherwise, if it does go into effect anyway, this in effect legalizes it through the back door, saying, well, you can be convicted, but we're just going to annul it. I'm trying to. Is there a dichotomy?
I hear what you're saying, definitely. And we had talked about this in the test in the hearing, but it's a high bar to get your annulment. It's a high bar to get your resentence. So it's not like you can just say to the court, "I'd like it annulled," and the court's gonna throw you out onto the streets out of jail. You have to go to the court, get your hearing, and then the court and the judge has to determine whether or not you're eligible for the annulment or the resentencing. And when they do that, most often we have a high bar with our court system. We have a good court system here. I mean, it's going to take that person's going to have to really have a case for annulments to be able to pass that bar. So it won't be everyone who's convicted for a marijuana charge can just say, "Oh, hey, Representative Wheeler passed 1539, so I can get out of jail free." No, it's not. It's very clear what is and is not eligible for annulments in the bill. So all I'd have to say is the personal use amount for eligibility for annulments, yes, would be that, but it's not legalization, because you're still being able to be arrested, convicted, sentenced, and serve out your full sentence if the court determines that you're not eligible for annulments, which would mean that it's not legalized.
Thank you. Representative Murray, did you have something else to add?
Thank you, Mr. Chair. Yeah, I would just add on to that, the position of the House has been to support legalization. We passed a bill to do so a couple weeks ago. And I think if the other body chooses a different position and ITLs that bill, it's safe to assume that they would also ITL this one. And so I think it would make sense for us to move forward, considering the position of the House, which is passing that legalization bill, and that we also want to pass this coinciding with that. And if the other body chooses different action, then they choose different action.
I would caution you against using logic anymore. Representative Stone.
Thank you, Mr. Chair. I'll be voting against this bill at this time. Under RSA 651.5, we already have an annulment mechanism that's in place for all classification of crimes, regardless if it was marijuana connected or another lower level non-narcotic possession or other various charges. With that said, if you look at the statute, most misdemeanor A's and B's are a 3-year span of time from completion of sentencing, in which allows you to annul it by petitioning the court. Since there's a mechanism for annulment already, I think it would be more prudent to look at the annulment process. In today's technology is advanced since this was originally passed back for annulments, and we could probably streamline the process. But I really have a hard issue on isolating just marijuana offenses for annulment. In addition, I want to make sure that we're only targeting, misdemeanor level offenses, violations. I don't want to see felony level drug dealing offenses being annulled improperly by passage of this type of legislation.
Thank you. Representative Newell.
Thank you, Mr. Chair. I don't think anybody will be surprised for me to say that I'm going to support this OTP. But I just wanted to address, I agree with what Representative Wheeler and Representative Murray said about kind of the process and how this works with the other bill. I think there's a differentiation here in that what this bill aims to do is to rectify the past. And we are, when we talk about legalizing cannabis, essentially, we are all agreed on the fact that we should. It's just how we go about it. What this bill does is say that based on the premise that we understand that part of the reason that we are trying to legalize cannabis is that there is it has done irreversible harm to people. So what this bill says is that on a base level, we understand that the criminalization of cannabis has done serious harm to people in our community, and this bill seeks to rectify the past, whereas the next one, the other one, the legalization moving forward, seeks to rectify, set things up for the future. I hope I'm saying that clearly. The differentiation between the two bills is that one sets us up for the future to go forward in a good way. This helps us reconcile what we've done in the past and to right the wrongs that we've done in the past. So.
Representative Selig.
Thank you, Chairman Roy. I also support this bill, having previously worked in real estate and for a company that does property management, and knowing how many people end up not being eligible to get rental housing because of past criminal records for something that, in my mind, should not have been illegal in the first place, to give people an easier avenue to get out of that so that it can be easier for them to get housing and also get employment so they can be more productive members of society, I think would be excellent.
Representative Reed.
I struggle with this bill because I honestly don't want people's lives to be destroyed because of a weed conviction. However, I don't think anybody's being arrested and sent to jail for much of anything these days, especially for a joint. So I think that they're being sent away for other things besides this. And those who were convicted or in the past for having marijuana, it was illegal back then. So going forward, marijuana isn't legal yet anyways. So this is like putting the cart before the horse. But again, I have to say, I don't want people's lives ruined for a weed conviction, but I don't know if this is ready for prime time yet. Thank you.
Further comments? Representative Muse.
Yes, part of the issue as I see it is it's not just a matter of people who may or may not be going to jail as a result of an offense like this today. I think another huge issue is the fact that this is an offense that just follows people. There are people I know who were arrested for possession in college who haven't been able to get jobs, who've had trouble getting housing. It's something that can affect your whole life. I mean, we look at this now as a minor crime, almost a violation level offense. We barely prosecute people for under 3/4 of an ounce of cannabis now, but it hasn't always been like that. And I think until we change the law so that we actually align it with where we are today, and where we seem to be today is on the precipice of actually making it legal for the state of New Hampshire to actually sell it to people. So if we don't do something like this, we would be in a position as a state where we are actually selling cannabis to people and bringing money into state coffers to do that. But we would have people who are still in a position where they have trouble getting jobs, trouble getting housing, and whose lives really have been permanently turned upside down because we're not fixing something that I think should be pretty easy for us to fix at this point.
Representative Stone.
Thank you. Again, I'm going to go back that I heard no testimony or supporting facts or circumstances that led that the annulment process we currently had been availed and then the individual was aggrieved by that process. If we already have an annulment process, why isn't it being used for all these people who are eligible to apply for annulment and choose not to and have their records sealed?
Representative Muse.
I think part of the reason for that is that the annulment process has a lot of built-in friction. It's difficult, I think, for the average person who's affected by this to sometimes, I think, to even know that an annulment process exists. It becomes something that I think you can get as a matter of a privilege. If you can afford an attorney, if you know what to do, if you know what strings to pull, this is something that you can do. But it's not something that's really readily available to the average person who's been convicted of an offense like this.
Shortly.
On the annulment process, you can find that on the judiciary's website, and it's approximately a $300 fee that you do not need an attorney to file for. You are aware of that.
Thank you. I think we can agree that $300 for some people can be pricey. Representative Wheeler.
Thank you, Mr. Chairman. Yes, I would say that
Oh, Linda.
$300 can be pricey for some people. And also, this bill is the automatic annulment statute. So I would say that it's the government kind of doing its job in saying, okay, here are these people who have served out their sentence, and now we can get them annulled. We don't have statistics for New Hampshire in general, but nationally, it's about 5 to 6% of people who are eligible for annulments get their crimes annulled because they're, as Representative Muse put quite well, not aware of the system. They're the average American who's not inundated with the criminal code and probably doesn't even know that it exists in a book form that they can read. And you know, I think that's most people who don't grasp the system that's around them. And that's why I think it's important for sort of the government to do its job in righting this wrong, and that's why the automatic annulment statute is there. I respect everybody on this committee and Representative Reed as well. The only thing that I'd have to say to you is I think it's sometimes you got to build your cart so that you can travel down the road, you know, and so I don't want to put the cart before the horse, but we don't even have a cart yet. So I'd like to build this cart so we can take people down the road here so we can make sure that they have a solid thing. So I totally I don't, you know, vote however you feel you need to vote, but I do think that this is a bill that's separate from legalization. You know, whatever, however you feel about legalization, this is about sort of, as Representative Muse put quite well, people's livelihoods. So that's the last thing I'll have to say, Mr. Chairman, and thank you for this discussion.
And thank you for using a cart instead of a magic bus analogy. Representative Harry Gathright.
Thank you, Mr. Chair. But actually, that's exactly what I was going to talk about, the fact that this, if you look at line 4 and 5, this is truly about, you know, automatic annulling. So he did an excellent job in explaining that, so I don't need to go any further, and I will be supporting.
Thank you. Okay, I think we've had just about enough discussion on this one. I'll close by saying I like Representative Reed, I'm torn on this bill. However, one thing, as it pains me to say, Representative Muse's argument made me think how hypocritical that we're contemplating selling this product, and people have a criminal record for possessing the product that we're about to sell. I don't think I can. That doesn't set well with me. So I'm probably going to support this, and if it passes on the floor, and let the Senate deal with it, how they deal with the other bill, and in their wisdom, maybe combine these to somehow come up with something that's proper. But I just don't, that bothers me. Representative Newman.
And I just want to follow on with your comment. I mean, we haven't decriminalized many other crimes at all. This is a unique situation where we decriminalize something where people have a record, and so it's different than the other crimes that are out there, and I support the automatic absolution.
To be clear, just to go on the record, I'm not a supporter of legalization at all, but I'm a supporter of common sense in law. And whether we're talking about marijuana or widgets, if the government's selling widgets and someone has a record for possessing widgets, to me that's not right. But say
And
let
I
me-
will disassociate myself from your previous comment.
no problem. Representative Murray, would you please call the roll? Motion on the floor is ought to pass.
Vice Chair Rhodes,
No.
Representative Pratt,
No.
Representative Colcom,
No.
Representative Prue,
Yes.
Representative Love,
Nope.
Representative Tudor,
No.
Representative Reed,
This is really hard for me.
You can do it.
You can do it.
Oh,
Vote your conscience.
I'm gonna go yes.
Representative Stone,
No.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
14-6.
14-6, the motion about to pass carries. Representative Wheeler, I expect you to write the report and be ready to argue this on the floor against Representative Stone, who will be writing the report for the minority and speaking. So that bout is set up.
When do they do by? Tonight.
ASAP, because this is crossover next week.
I can get that tonight.
Actually, what is today?
minutes ago.
Wednesday? Yeah, you got 40 minutes to make the calendar. We're going to take 5 minutes. I know we've already been missing. That was because we were held hostage by the Senate, but we need to discuss one more bill before we take it up. Both parties are requesting. If we could, Republicans could meet in my office real quick.
Wheeler and Newman and Murphy, please.
I'm opening the executive session on House Bill 1366. And I'm going to make a motion, to introduce an amendment. And the amendment number is going to be 011H. Can I have a second? Second by Representative Stone. I'll speak to the amendment. I really don't have much recollection of this bill other than the fact that I apparently got an amendment for it, and I'll read it. Reckless operation of boats. Any person who shall operate a power boat. Are you guys okay over there?
No, we're not. Mr. Chairman, Representative Gathright,
Yes,
did we already accept this bill?
yes,
Is
we
this why
did.
we're all confused?
On January the 19th.
That might be why I have no recollection of
Right.
it.
Me
We're
too.
all set. It passed. Ought to pass as amended.
So it's on, I think it's on our list.
Is this
of-
Groundhog Day?
No. Because remember, or if I remember correctly, we had to recess it because we had to fix do we already know this? Am I
minute, do we
repeating
know the
people?
story?
Because we had to fix the fact that it was in both statutes. It said, both sections, it said the same thing.
Let me
So
just
did we
ask the
accept
question.
and then?
We recessed it so that we could have an amendment that fixed it.
And we did get it. So
So
the
this-
amendment number is 0111H.
I believe this is the amendment
Okay.
that's been handed to
On
me.
January the 19th,
Yeah.
okay, we did 0111H 20 to
Why
0.
don't you save it?
Then we did ought to pass 20 to 0. So I don't know what,
All right, this was put on here by
go through the
Iris.
process again?
No, I'm not redoing it.
What our
I spoke
executive
to,
session said, that's all. We're just
to
looking at
our
the agenda.
assistant, and she's the one who gave us this to go on the agenda. So
Oh.
I'm going to recess this non-existent bill for a minute.
Could you ask Karen? Would you mind? Thank you.
Yeah, thanks. And in the meantime, we'll take up something much less controversial. I open the executive session on House Bill 1711. And I make a motion of ought to pass.
Second.
Who seconded that? Representative Harry Gathright? Oh, Representative Prue seconded that. I'm going to, I'll speak to my to my bill. So this is a really, really difficult bill. But at the end of the day, it comes down to a simple concept. As all of you know, I am one of the staunchest Second Amendment defenders in the House. That being said, I cannot with a straight face tell someone that someone who is dangerously mentally ill should be able to walk into a gun store and purchase a firearm. Someone who hears voices telling them to do things, someone who has these dangerous inclinations and has been found so by a psychiatrist and a court with an attorney at a hearing. That's the person I'm talking about. I don't know how I could tell the family of Chief Haas or any of my constituents, I think it's okay that they can buy guns. Now, I understand that anytime you cede power to the federal government, it's a very dangerous thing. That being said, the federal law is already in place. Once you have been adjudicated dangerously mentally ill and committed, and that's what this bill is about, people who are committed for the most part, you're automatically a prohibited person, whether you know it or not, or whether the state informs the federal government or not. If you're arrested and you have a firearm, you are subject to be prosecuted for a 10-year federal felony. So there's that aspect of it. The second aspect of it is this. Right now, anyone in this room could go see their therapist tonight and tell their therapist, you know, I'm so mad at my spouse I could kill him. If they think that you might be serious, they can report you to NICS. And there you are. You're on NICS. You're on the list. And guess what? You can never get off. Ever. There's no process in New Hampshire for the restoration of rights. For the federal government to take your name off of NICS, your state has to have an approved restoration of rights statute. That means you write a bill, it passes into law, the ATF looks at it, it meets their criteria, they say it's approved. Now you can get your name off the list. New Hampshire has no such statute. So anyone on the list right now from New Hampshire is there for the rest of their life. So at the same time, we have people who are dangerous being able to purchase firearms in New Hampshire, and we have people who may no longer be dangerous unable to get their name off the list so that they can purchase firearms. So what this bill does, it makes a very narrow process to have someone's name sent to the federal government, and it gives them a way to get back off that list. I also, due to lack of trust with things at the federal government level sometimes, put in there that this law cannot take effect until after the ATF approves our restoration process. That means if there's no way to get your name off the list, your name can't go on the list. So I took every step I possibly could to make sure that people's rights were protected and that only the people who are dangerously mentally ill and haven't been adjudged so by the court with a representative, a lawyer, and if they couldn't afford one is provided for them, would be put on this list. Only people that were already prohibited by federal law from possessing a firearm are going on this list. And even it's only temporary. And if they get better and they have their treatment, they can get off the list. So with that, I have nothing further to add. Representative Prue, did you want to speak to your second?
I do. So I agree this is not the perfect bill, but it does head in the right direction. People who are seriously ill need not be able to have access to firearms. And I also like that we're putting in restoration of rights. So if it's a misunderstanding with your therapist, you get better, right? Because we all know that the end goal of therapy and mental health medicine is to get you better, make you stronger. And a lot of times it's just one issue that you work through and you come out the other side in a way better place than you went in. So to be able to get off that list after you gotten better is significant, I think. So I'm going to vote for this.
Thank you, Representative Rhodes.
Thank you, Mr. Chairman. If one of the things you did not touch base on that I think would be helpful is an example of where a red flag law is different. Is an example if somebody were to call up and say it's an ugly divorce and there's an accusation made, where a red flag law would be different than the situation that is here. If you could maybe talk about that for just a second, address that.
Sure. Well, depending on which red flag law, generally speaking, ERPOs, those laws, what they do is they allow someone close to you, a family member, friend, neighbor, to be able to go to law enforcement and say that I have serious concerns about this person's mental health, at which point they can issue, the police can get what's called an ERPO, emergency order, to pull your firearms. It kind of flips the script. In other words, it makes you have to prove you're sane versus the state having to prove that you're not sane. Whereas this law, that's reversed. The state has to prove that you are dangerously mentally ill instead of you proving you're not. So that's one of the key things. And second thing is not everyone can just go in and apply for you to be involuntarily committed. It takes, I think it takes several people. I mean, it's very complex to get somebody committed in this state. It's not easy. And someone off the street who doesn't like your politics can't just go in and say, I think that person should be involuntarily committed. So it's a much, much different standard between the two. And I would add that as far as pro-gun states, it's difficult to think of two more pro-gun states than Florida and Texas, and both of them have this exact law. Representative Newman.
Would you just clarify, your motion was ought to pass or ought to pass as amended? There is no amendment associated with this? Okay, so previous amendment would not be, okay, thank you.
Representative Muse.
I just wanted to briefly speak to the amendment because I believe we have to vote on the amendment first.
Representative Newman just said that, and you'll have to excuse me.
have an amendment, and it's for this bill. I just,
Whose amendment is it? Mine, please.
it was a February amendment, and it was you.
We have an amendment dated February
Was it,
2nd.
it was entered that day at the hearing when I was gone?
I don't know. I just have
Where
a
is it?
copy. But it
Stand
has-
by.
has not been entered.
I thought it was entered while I was gone.
This was the amendment, Representative Roy, that the Disability Rights Center proposed, and it has some pretty significant changes that I think are probably changes we would all agree to.
Yeah, I recall it, and I thought that it was introduced already that day that I left, and the hearing continued because I had to leave. So we will introduce the amendment. So I believe my motion was not to pass. I need to withdraw that motion. We need to introduce the amendment. Representative Prue, thank you. The motions are withdrawn. I recognize Representative Muse to make a motion.
I move to pass HB 1711 with amendment 2024-0431H.
I second that. Would you like to speak to that amendment, please?
I think one of the main objectives we've had throughout this process is to make sure that whatever we do doesn't further victimize and stigmatize people who are already victimized and stigmatized enough, and those are people with mental illness. While it's absolutely critical to close a critical public safety vulnerability, I think one of the things we've tried to do every step of the way is to consult with people in the mental health community, in the disability community, and even with some of the folks who work at New Hampshire Hospital on what this bill should look like and how it should take shape. So as part of that process, Karen Rosenberg, who is the policy director for the Disability Rights Center, noticed some things in the bill that she suggested fixing that would make it essentially easier for her organization to sign on. And I'll just review some of those things very, very quickly. One of the things the amendment does is it requires judges to inform the person who's under adjudication that a seizure is a possible outcome, and it makes them aware that they can request a hearing on involuntary commitment, and they can also make other arrangements to turn in their firearms rather than simply having a law enforcement officer confiscate the firearms. Another thing that it does is it reduces the time frame for the process that guns would be returned to someone who's proven that they're no longer a danger to themselves, to others. The original bill had a 6-month time frame for that to happen. The amendment reduces that to 60 days. The amendment also restricts some of the sharing of personal information. So the original language basically said that any non-clinical identifying information could be shared. What the amendment does is it restricts the sharing of personal information simply to the information that's needed to get somebody's name up on the system. So that would be their name, it would be the applicable prohibition, it would be their date of birth and their social security number. So no clinical information of any kind is actually being shared with the FBI or anyone in the federal government. That information is retained in the New Hampshire judicial system.
Thank you, Representative Muse, and thank you, Representative Newman, for bringing that to my attention. I was absent the day this bill was brought forward, so I thought I left the amendment. I thought it had been adopted because as you may have noticed in my discussion, I mentioned some things that were already in here. So, having said that, further discussion on the bill and the underlying amendment. Yeah, Representative Stone.
Yeah, on the bill itself, I support it about 90%. And with that being said, I'm going to support making a motion, excuse me, not a motion, but I'll be voting in a yes to send it to the House floor. One of the aspects of this bill that it really stands out to me is the process of due process, that both removing firearm rights and reinstating firearm rights, which is crucial. An individual should not have due process stripped from either direction, whether it be in the beginning or the end. This bill does rectify that. In addition, a judicial process is involving an attorney that is there to represent a individual. The attorney will safeguard their rights as well during the hearing process. The judge will make the final determination. It's not just a psychological or medical issue that's brought up. So the due process provided by a hearing is instrumental in providing individuals' rights. And that's the best takeaway I have of this bill.
Thank you. I would call everyone's attention to the fact that in 2016, Representative Holt introduced a bill that became law as part of the Medicaid bill that specifically said no one shall have their firearms taken away by reason of mental health issues unless they have a hearing before court and they have an attorney present, which is basically what this does, except it also gives you a way to get your firearms back, which his didn't. Representative Seal.
Thank you. Thank you, Mr. Chair and committee. I support the bill and the amendment. I used to live in a community where we had an indigent person who suffered from a recurrent mental health illness, and he would get hospitalized. He would get stabilized with medication. Once he was stable for 2 weeks, they would release him because that was as much coverage as he had for insurance. He would then cease taking his medications, and we'd go through the cycle over and over again until he each time got to the point of attempting to break into a business or do some other kind of thing that frightened people, and then would end up back in the hospital, back being involuntarily, committed. And he's the kind of person who this bill addresses, right? He should not, he was not able to maintain stability in a way that kept him safe to be in society. And because we don't have a structure to provide him the type of life support, overall life support, I don't mean like breathing, but functioning support in our society as it exists right now, he would not have been someone who would have been safe to have a firearm because no one would have ever known when the voices were telling him to do things. So I think it's a good bill. I think it's essential that we work to protect people and that we have a process to protect all of them.
Thank you. Further discussion? Seeing none, the motion on the floor is to adopt the amendment. And I'd ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
No.
Representative Colcom,
Yes.
Representative Prue,
Yes.
Representative Love,
Yes.
Representative Tudor,
Yes.
Representative Reed,
No.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
18-2.
18-2, the motion is adopted. I make a motion of ought to pass with amendment. Seconded by Representative Prue. I believe the discussion has covered every aspect. Unless someone has something they want to add that wasn't said, I would ask the clerk to call the roll. The motion on the floor is ought to pass with amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
No.
Representative Colcom,
Yes.
Representative Prue,
Yes.
Representative Love,
Yes.
Representative Tudor,
Yes.
Representative Reed,
No.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
18-2.
Any objection to consent? Seeing none, it'll go on consent. And I close the executive session. Now I'm opening the executive session on that last. Apparently, I was right in the first place on HB 1366 about crazy boat drivers. Where are we at?
Mr. Chairman, it appears that we are all a little bit right and wrong. So we did vote on this bill and we did pass it on the consent, I believe it was 20-0 with an amendment. And we, if my understanding is, if my memory is correct, we actually made a motion to I think we like withdrew the motion because there was, I believe, something with an amendment, and Representative Knoll seems to have a better memory exactly. But I do know on my list, I crossed it off, so I know it was taken back. Our lovely assistant has informed me that exactly what I just said. We did vote on it, and then I crossed it off, so we turned it in knowing we were going to come back to it today. But I don't remember the reason, but Representative Knoll seems to, if you don't mind her.
Yeah, I apologize. I don't have the bill in front of me right now, so I'm just going to give. There was an A and a B, and we had an amendment to separate the A and B because they were different levels of offense, right? So, but when we separated it out, we didn't change the language in a way that comported with those being two different things. So there was one phrase that was repeated in both that really needed to just be in one. And I'm sorry, it's not specific because I don't have it in front of me. If anybody does, I can tell you exactly.
Mr. Chair.
We're trying really hard not to have too many people talking about it.
It was the or.
No.
Yep.
Oh.
It
Okay,
was-
so
In the amendment, it was in a reckless manner or so that the lives and safety of the public are endangered. I think we were supposed to get rid of the or. I can't find it in my notes, but whoever spoke about it wasn't recommending the or in between those.
It was our, there was a sub from judiciary who had been the,
both of them, both A
and
and B. Oh, I'm
he,
sorry.
he was very explicit that the way that it was written made it unclear, would make it unclear for a justice to know what the full intent was, and that we needed to remove the word or in order to have it correct. And I am sorry that I've lost his name in my memory at this
Representative Lynn.
moment.
Actually, he is the former Chief Justice of the New Hampshire Supreme Court.
So it's because having that phrase, so that that the lives and safety of the public are endangered, having that phrase in both A and B make it so that those are equivalent. So it's hard to parse out. So we needed to take it out of one of them.
And I have an amendment in front of me, 011H, and I'm not sure if that does that or not.
He said it did not.
So we did.
We recessed it so that it could be sent back to have the or removed.
We forgot.
Yeah.
So we do not have the correct amendment
So
that
I'm
does
so
what we
sorry.
needed today.
So, okay, first of all, just anyone watching at home, we are not normally this messy. The Senate held a hearing on one of our most important bills this morning, and it really kind of threw a wrench into our structure. Yeah, so having said that, we are up against the deadline on this bill. So I recommend that we vote ought to pass with amendment as it is, and we can fix it with a floor amendment, just so that we have it off our table at this point. Representative Murray?
Did we, when we recessed it, did we not already land on OTP? Did we not already vote on that?
I think we did, but maybe we didn't transmit it to the clerk.
That's correct.
Yeah.
So if we've already voted, I'm just going to say transmit it and we're done.
Yeah, that's what I thought.
If we voted. Hold on, the researcher is approaching. Okay, what we're going to do is we're going to call the roll and ought to pass as amended. We're pretty sure it went 20-0, but we can't be sure, so we're going to do a belt and suspenders. So I'd ask the clerk to call the roll of ought to pass with amendment on this bill, just to cover us, and we will look at fixing it on the floor.
So Representative Roy, you had made the motion of ought to pass, so we'll just go with that. Okay.
Ought to pass. with amendment. Yeah, second it, please. Second. All right. Ask clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Colcom,
Yes.
Representative Prue,
Yes.
Representative Love,
Yes.
Representative Tudor,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salick,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, motion passes. It'll go on consent, except for I'm going to have to pull it to do an amendment. What? I'll have to pass with amendment. But it will not go on consent because we need to amend it. So what? All right. So now we have to do out to pass with amendment, same vote, same deal. I make the motion, Representative Harry Gathright seconds, and the clerk will call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Colcom,
Yes.
Representative Prue,
Yes.
Representative Love,
Yes.
Representative Tudor,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Sue Newman,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salick, Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
Okay, 20-0, motion carries. I hereby close the executive session. And the next time Representative Lynn subs, I'm going to assign a representative to stick with him and write down and take amendments from all his little judicial pearls of wisdom he leaves us with. With that, we are good until I'll see you all tomorrow. And next Wednesday, we start taking up Senate bills. And I believe we have. Wait a minute, hold on. What? Which is, oh, that, I'm sorry, that's right, 1046 from this morning. While I was over at the Senate, we heard that. Let's just dispose of that. Open executive session on House Bill 1046. And I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ought to pass for House Bill 1046.
Seconded.
Representative Brewer already got it.
Okay. Would you like to speak to your motion?
Thank you, Mr. Chairman. So basically, this morning we had basically heard that that it appears there's some situations where people possibly could be renting motorcraft, and if they may be involved in an accident, they're turning the boats back in. There may be an aggrieved party, but there isn't anything coming forward to say. So basically, the person rents the boat and leaves, and it's very obvious that that there has been damage done, and nobody wants to say anything about it. So this actually does put a threshold of $2,000, and it also clearly says reasonably or reasonably should have known. And he was very much able to explain what should have known actually could mean. I had given an example of a boating accident that I was in a while ago, years ago, that kind of explained what this kind of was about. And there was only a couple questions, and I think it was very, very much straightforward. There's really nothing bad about this at all. That was a word salad, but you get
Would
it.
you like to speak to second, Representative Pro?
Sure. I think it just puts some responsibility, like you would have in an automobile. You get in a car accident and you have to report it. And now they're just saying, if you're in a boat accident, more than $2,000 damage, anything it touched, you have to report it. So that's common sense.
Further discussion? Seeing none, motion on the floor is ought to pass. Ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Colcom, Yes. Representative Prue?
Yes.
Representative Love?
Yes.
Representative Tudor?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Harry Gathright? Representative Muse?
Yes.
Representative Sue Newman?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Selig?
Yep.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
20-0.
20-0. Any objection to consent? Seeing none, we'll go on consent. Motion carries. With that, we are done till next Wednesday, except for tomorrow for a session.
I got it. So we